Good morning. So I wanted to post a video today a little bit about how to prepare for a deposition as a plaintiff in an employment litigation case. And I think there's a few things that are very important, three specifically. I think it's critically important that you remember the facts and you have them straight. It's going to be essential that at trial you're able to communicate the facts in an understandable and believable manner. Now, you may not be lying in what you're saying, but if you're not clear, you're not confident, and you're not concise and understandable in the way in which you communicate those items, you're not going to be an effective witness at trial. And what is happening as a witness at trial is the defense attorney is having the opportunity to grill you. He wants to see if you stay cool. He wants to see if you say something stupid. He wants to see if you go off on a tangent. I can't tell you how many times, unfortunately, where my client will start going down a road we don't want to go down. And I'll do my best to try and get us back on the correct road, but I'm not in control. You are effectively at the mercy of the defense attorney during the deposition. So you just stick to exactly what the facts were. You communicate concisely. You don't speculate. You just share your story in the same concise manner in which you probably told your plaintiff's attorney when you first spoke with him or her. So just make sure you go through and review the case, because a lot of times these depositions, especially in EEOC and administrative processes after the fact. So if you spend a year and a half in EEOC going through the discrimination process, and then it took you 6 months after filing in federal court or state court to get to deposition, it might be 2.5 years. You need to have a concise overview of what you're dealing with. I didn't even get through the three things, and we're kind of getting long on this video. So this will be part 1 of 3. But the first and foremost, you got to have your facts straight. You've got to understand it. And I'm not saying fabricate facts. What I'm saying is you need to remember what you were supposed to do 2.5, 3 years ago and what the facts were. So just make sure you review your notes. And I encourage each of my clients, before they walk in my door, before we file anything, I want a big binder full of exactly what happened. I want a timeline. And that timeline is so critical to moving forward with the litigation and you having a firm grasp of the facts. Because a lot of time our mind will play tricks on us. Have you ever seen somebody who thought they remembered it one way and they believe what they remember based upon what happened? I don't want that to have happened, because when you have inconsistencies in your memory, it makes you look like A, you're lying, or B, you have no clue. And you're not a good believable witness if you can't be taken at your word. So if you mix something up that's not really relevant to the case, but the defense hacks upon it and undermines your credibility, you can be put in a very difficult position. So you just have to make certain that you know your facts, you understand your facts, and you stick to your facts. Because when you allow yourself to be challenged because you started going off on a tangent that doesn't really matter to the case, you can undermine your credibility in the core facts, and you can hurt your case. So just remember, write down everything as early as possible in the litigation process. Read through it. Every time you do something, every time you see your attorney make a motion, say something in court, send over requests for productions, every single step, you want to make sure you remember everything. And you want to make sure that everything's being considered through that process. So best of luck out there, guys, and this will be part 1 of preparing for deposition in a plaintiff's employment law or employment litigation case. Thank you.